Hi everyone, it's Kelly Amstutz, the Genealogy Investigator. Thanks for jumping on with me today. Today we are going to talk about land records and genealogy research and how to use them. So land records are one of the most underutilized resources in genealogy, believe it or not. What once brought immigrants to America was the ability to obtain land. It's usually completely forgotten when a genealogist sits down to start research. So established countries like Europe, they almost had all of their land titled for years, even centuries, by the time that immigration started to America. Um, there were different laws. For instance, there was one that said that the inheritance could only be by the first son, which ensured that properties wouldn't be split up into smaller parcels. But think about that. That also meant that other children couldn't inherit that land. In America, residents could amass large estates and distribute their land however they wish without laws or stipulations. So, all of a man's sons and later even his daughters could be heirs to his or her estate. So that can be really enticing if you are in Europe at that time and you're thinking like, oh, I'm living on this land and it's my brother's land and I'm never going to have any rights to it. That can really be enticing, right? Land records were actually the first records that were created in new areas open for settlement. So, as the land started to change hands through sales and inheritance, establishing records of ownership was really vital, as you can imagine. I have some great tips on how you can effectively use land records by understanding what records are actually available to you, what they include within them, where you can find them, and most importantly, how to use them. So let's go ahead and jump on in. So the types of land records that were available, they're really going to vary depending on the time and the place. In general, there are two types of records that exist. The first one is patents, which are also called grants. The second one is deeds of sale, which are also referred to as deeds for short. The primary difference between the two records is or who is doing the granting and the selling. In a patent or grant, a government is the grantor of the land. A deed record is a subsequent transaction between private parties, even if one of those parties is a business. So all of the following types of land records can really provide you with a treasure trove of information that can help find residences, figure out social status, or even just clue you in on identifying those ancestors that you're looking for. So the first one we're going to talk about is patents and grants. America's first records of land ownership are grants. This comes from the country claiming the land has been issued to an original settler. The English crown made grants in New England, Virginia, and its other colonies. So France would grant land in Louisiana and the upper Midwest. Spain and Mexico granted land in Florida, Texas, and other parts of the Southwest. States in those areas were called state land states. In public land states, the United States made those initial grants. So just kind of, I'm going to reference that a lot. So state land states and public land states. I do have a great free download that lists out the state lands versus the public land states. So I'll go ahead and include the link below, but be sure to grab that. It is a great resource for fellow genealogists just to kind of help you keep track of what is a state land and what is a public land state. A grant specified an amount of property owned and usually a location of that said property. The area might not be described in terms of measurements though. It might be something more like as far as the eye can see, which could easily introduce a potential for duplicate claims that later had to be settled in court, as you guys can imagine. Not all grants survived, but later documents often refer to old grants or deeds that may have been transferred in ownership to others by virtue of the original land grant. The result was that these deeds may have been the earliest surviving records for any given area. The Homestead Act of 1862, which I'm sure everyone's probably at least heard of, so you're somewhat familiar with it, that would allow the settlement of public lands with certain requirements, such as copies of an immigrant's naturalization paperwork, final land patents, or cancellation paperwork, which would be generated by the land entry case file record. Veterans of the American Revolution through the Mexican Wars were actually compensated with military bounty lands. Applications for bounty land warrants may contain information which can be important to genealogical data, and that can be included in the military service details. Next, I'm going to talk about deeds. After the initial grants, the local offices, which was usually the county recorder's office, they would handle that subsequent transfer of property ownership through various types of deeds. A quitclaim deed, it would indicate that the seller gives up all real or perceived claim on a property while not making any guarantees on their right to sell that property. It's usually used if there's like a question as to whether some unknown person, maybe like a missing heir, has claim to that land. Quitclaim deeds also are used when a deceased landowner didn't leave a will. All surviving heirs who might have a legal interest in that land, they're going to sign the deed, giving up any interest that they might have in the actual property. And then a warranty deed is another one. It was the most common and legally complete type of deed. It means that title to the land has been proven back to the original owner. The seller guarantees that he has the right to sell the land and that no other parties have any claim against it. Then the sections within a deed. So deeds, they're usually going to have a standardized boilerplate phrasing in addition to information on your ancestors and their property. So the introduction is going to give you the date, names, and descriptions of the parties that are in for consideration or payment that is being made. The grant for who is getting what from whom, and then any expectations are going to be listed. The next two sections, they may be merged into one in some cases. I did find a deed where it only had one section, and then usually it has two. But that's going to indicate the interest in the property the deed grants, the party who has title to the land, and any trustees or any additional conditions that might come with that land. So a deed might have a section in which the grantor reserves something, such as like mineral rights I've seen, for himself, or someone else if that's identified. And it's often using terms such as yielding or paying. A great example, some early colonial deeds, they're going to retain part of the property as rents for the crown that were originally granted the land. So you might come across that. In another section, the grantor warrants the title of the grantee. So sometimes covenants and conditions might require one or both of those parties to do something beneficial or even abstain from something harmful. An example is a deed from a father to a son. They require the son to maintain a home for his parents on the property. This is often to see that when the father expects to die soon, he wants to ensure that his widow is cared for after his death. Within the conclusion, you're going to see the mention of an execution of the deed and the date. It's either going to be expressed or referenced to the beginning of the document. So it'll say like here above written. It's going to name the witnesses and parties signatures, and then it'll be followed by a seal. That's just the standard procedure. Many jurisdictions, they're going to require that a widow's examination until the early 1900s, a wife was entitled to widow's rights or dower rights of her husband's property, but she often could not directly control it or sell it in her own rights. This was supposed to ensure that if a widow she couldn't become a burden to the community. So she was required to send a statement that she was aware that her husband had documented selling the property and she was losing her dower rights to it. That means that she wouldn't have to be cared for by the community. She was already settled into that property. I do recommend reading several different deeds before and after the one of interest, just to determine whether it varies from the typical wording of the time and place. Major variations could really raise a flag. It might be something that you want to investigate a little bit further. Plat maps are a great resource because they're going to show precise locations of those properties. Where they're available, they can put the land into context with names of your ancestors and his neighbors even. Locations of towns, roads, lakes, schools, waterways, and even churches. So that's just something that I think can really come in handy if it's accessible in the area that you're researching. And then locating land patents. I get asked this every once in a while. Where do I find land patents? So before 1908, patents for land were filed by state land offices or by the act under which they were sold. After 1908, each patent was assigned and filed by a unique number. So the BLM General Land Office Records Database, which I'll put a link below, they're going to contain 5 million records that date back as far as the 1820s. You can search by name and location to find an original landowner, military bounty, land warrant holders, and even homesteaders. So once you locate that patent, you can order the land entry case file from the National Archives and Records Administration, the NARA, just to see your ancestor's application for the land and any document that he would have filed with it. To require the land entry case file from the NARA, you are going to need some or all of the following details. You're going to need the name of the purchaser, the state in which the land was located, and the approximate date of entry. And that's just standard procedure. In addition, for entries before 1908 from the Eastern Public Land states, and that's going to include Arkansas, Illinois, Indiana, Iowa, Michigan, Minnesota, Mississippi, Missouri, Ohio, and Wisconsin, you're going to need 3 additional pieces of information. You'll need the type of file, the name of the land office, and the land entry file number. For entries before 1908 from Western public land states, and that's going to be California, Colorado, Idaho, Kansas, Montana, Nebraska, New Mexico, North Dakota, Oklahoma, Oregon, South Dakota, Washington, and Wyoming. You're going to need either the legal description of the property or the type of file, name of the land, of land office, and the land entry file number. So for surrender of military bound land warrant files, you're going to need the warranty's name, the year of the act, the warrant number, and the number of acres. You'll find this information by searching the BLM site if the warrant was issued and used. If not, you can check the person's military pension records because it should be in there too. All copies of the land entry files from the NARA do cost a fee, but if they do a search and they can't locate any records, there is no cost. If you pay by check, the NARA will actually invoice you before mailing the file. So finding deeds, because I do get asked, how do you find deeds? In Ohio, our recorder's office is really awesome. But a county recorder's office, which is usually an office of the courthouse, they're going to house these types of records for deeds. Old deeds may still be located there. In our case, our house was built in 1892, and our recorder's office did still have the deeds on file, which was awesome. But they can also, if they're not still housing them, they can be sent to the state archives or maybe another repository, and they're going to have more information on how to get in touch with those property deeds. The deeds are going to be recorded in the county that had jurisdiction over the property at that time. If you're not sure, which county to search in, because county lines did change, this is a fact, you can always reach out to the recorder's office, as they are really, really helpful in most cases in these types of matters. Even if the county boundaries moved later, the deeds would have stayed within the county that they were recorded originally. So that's just something to keep in mind. And if you're not sure where your family lived, you can always check those US Census records and utilize the city directories just for clues as to where to find your family. I do have some great resources that I would love to share in the comments for land records, different websites that are super, super helpful. And then just some publications and resources that you might want to check out. Some really helpful tips that I do want to share is skim other deeds that are surrounding your ancestors just to become familiar with the handwriting. This is really going to make it easier when you're analyzing your ancestors' deeds. And then deed indexes are usually arranged by the first letter or 2 of the grantor's or grantee's surname. but they aren't strictly alphabetic beyond that. And then land record research isn't just for rural ancestors. City residents would own land too. Even renters could create land records, but they usually put them in the name of the landlord. Just things to keep in mind. As usual, I hope you do join my mailing list to get my newsletters delivered directly to your inbox each week. I'll put the link below. The Genealogy Academy, my 6-week self-paced course, is now opened. It teaches you A to Z how you can do what I do as a professional genealogist. So please check that out. And then last but not least, I do have some openings. I am starting to book up though. If you're looking for any service based genealogy research, I do personalized genealogy research. I also do family trees, pedigree charts, and DNA consulting. So if you're interested in any of that, I'll put my email below. Please feel free to reach out. And then be sure to check out my other blog posts. And that's it. I'm going to leave you guys for now. I hope everybody's having a great week, and I'll talk to you soon.